In a stunning verdict that could reshape how tech companies handle user privacy, Google has been ordered to pay over $425 million in damages for secretly collecting app data from millions of users, despite those users explicitly opting out of such tracking. This case shines a spotlight on the growing tension between consumer privacy rights and the business practices of tech giants, leaving many to wonder, are we truly in control of our own data? But here's where it gets controversial. Are these actions deceptive, or simply a misunderstood aspect of modern technology? At the heart of this legal battle is a group of nearly 100 million Google users who claimed the company continued harvesting their personal information even after they turned off specific privacy settings in their accounts. These settings, known as Web App Activity and its subsetting, Supplemental Web App Activity, were marketed by Google as tools that gave users control over what data the company could collect. However, plaintiffs argue that toggling these features off did nothing to stop Google's data-gathering machine. The trial took place in San Francisco, with jurors ultimately siding with the plaintiffs on the issue of privacy violations. They determined that Google had indeed collected user data without proper consent. Yet there was a twist. While the jury agreed that compensatory damages were warranted, they stopped short of awarding additional penalties under the California Comprehensive Computer Data Access and Fraud Act. Why? Because they found no evidence that Google's actions caused direct harm to the affected users. Lead plaintiff Anibal Rodriguez initially filed the lawsuit in July 2020, accusing Google of misleading customers into believing they had full autonomy over their data preferences. In his closing arguments, David Boies, a renowned attorney representing the plaintiffs, painted a compelling picture of deception. He accused Google of pushing a control narrative, suggesting that the company falsely assured users they could manage, view, and delete the very data being collected behind the scenes. This isn't just about miscommunication. It's about giving people the illusion of choice while maintaining complete control, Boies explained passionately. What kind of system allows a company to claim compliance when the reality is so different? On the other side, Google's defense team, led by Benedict Herr of Cooley LLP, countered that Google believed it had implicit permission to gather certain types of data, even if users opted out of broader tracking. Herr emphasized that Google provides clear disclosures about ongoing data collection through notices and FAQs. Google tells users upfront exactly what happens when they toggle off supplemental web activity, he argued. There's transparency here, not deception. Herr further contended that none of the class members suffered any tangible harm. This isn't a case of leaked data or malicious intent, he stated. It's about interpreting technical language in a way that aligns with reasonable expectations. Despite these defenses, the jury awarded the class more than $425 million in compensatory damages. The staggering figure reflects the immense scale of the alleged misconduct, encompassing nearly 100 million devices and spanning several months. During closing arguments, Boies had requested an astronomical sum exceeding $30 billion, citing the high value of the harvested data and the prolonged duration of the alleged violations. Interestingly, jurors expressed mixed feelings about the outcome. While they acknowledged that Google's actions merited compensation due to the inherent value of the collected data, they hesitated to grant punitive damages. Their reasoning? They didn't believe the plaintiffs had suffered significant losses, nor did they think Google would face major financial repercussions without the disputed data. After the verdict, one juror quipped humorously when asked whether they planned to disable the supplemental web app activity feature themselves. Now we know it doesn't matter. Michael Bowman, the jury foreperson, delivered this remark with a laugh, underscoring the frustration shared by many regarding the complexities of digital privacy. Presiding over the trial was U.S. District Court Judge Richard Seaborg, an appointee of former President Barack Obama. His courtroom became the stage for a pivotal debate about the ethics of data collection and the responsibilities tech companies owe to their users. So, what does this mean for the future of online privacy? Is it time for stricter regulations? Or should users accept that some level of data collection is inevitable in today's digital age? We'd love to hear your thoughts. Do you think Google crossed a line, or is this lawsuit merely a reflection of evolving societal norms around privacy? Share your opinions below and join the conversation.